and Roderick Mulgan, please, to the table. And do we also have a Michael Bott?
Yeah.
Welcome, gentlemen, to the Justice Select Committee. We're not going to muck around. You've been in the background listening. So thank you again for your written submission. We've got you down for 15 minutes. So again, apologies for the late start. Time is now over to you.
Indeed. Good morning. Thank you very much for having us. And I am Patrick Winkler. This is Roderick Mulgan. And next to him is Michael Bott. We practice, Bott, B-O-T-T, I mispronounced. We practice in criminal law, and we are strongly opposed to particularly two of the proposals in this bill. And they are, first, the proposal to force defense counsel to record their cross-examination prior to trial. That's clause 14. And second, the proposal to prohibit relevant evidence of a prior sexual relationship between the defendant and the complainant, and B, of the complainant's sexual disposition. That's clause 8. So Dr. Mulgan will speak on the first issue as to pretrial cross-examination, and then Mr. Bott as to the second issue of prima facie outlawing relevant evidence. And we hope that our process will leave several minutes for questions that we hope you will have.
Thank you.
Thank you. Now, look, I'm aware that this is a well-traversed issue this morning, so I thought I'd keep my remarks to really this issue of pre-recording cross-examination. Why does it actually matter? You've heard a lot of submitters talk about the nuts and bolts. You know, you don't have your disclosure up front, therefore you can't do it. So I like to suggest that it actually goes deeper to the integrity of the trial process. It's got to be pointed out that there's already well-established procedures and often used procedures for a complainant to record her main story ahead of time. And it's what's called evidence in chief. What you want to say, that's usually recorded shortly after she comes into the police station, that then gets played to the jury. All we're talking about is the part of the process where the defense lawyer gets up and says, no, I want to ask you about these things. The reason that it matters is that the defendant and the defense team have the right to not let it be known how they're going to attack the story. And this is often called the defendant's right, the right to silence.
Can I just interrupt you just for a second? Is that I don't know whether it's accepted to, if you've got a victim that goes into a police station, she's given you evidence rather than telling the story. I don't know if that's, maybe I'm just being pedantic, but it sounds to me like you're somehow cheapening it by saying that it's a story. When she's actually,
well, it's her version of events.
Yeah,
that's what I mean.
Yeah, I just wanted to. I was just flagging that up personally.
Sure. I'm not cheapening it at all. Her
Okay.
version of events.
Yep.
What happened?
Yep.
I'm saying this is what happened.
Like I said, I may be being pedantic,
Sure.
but it just sounds like you're saying this is her story. Actually, it's her evidence.
Yes.
That then
Yeah,
will
of
get
course.
tested later. Yeah.
So the defence team have the right not to disclose ahead of time where the weaknesses are going to be found. And this is because the trial process depends on the prosecution being able to show. Now, if the prosecution know ahead of time what defence witnesses might say, where they might pick holes in the story, what they say is going to happen, this can affect what prosecution witnesses say. Memory is malleable, memory is suggestible. And for hundreds of years now, the common law has recognised that the prosecution has to give its version of events, its evidence, without knowing, because then it will be coloured. So for instance, to give a very simple example, when you give evidence in court, you're not allowed to be in the court until it's your turn. So you can't sit down the back like we've been all morning and hear what everybody else has to say. That will change your testimony. So when a lawyer cross-examines a complainant, they have an obligation that they must raise with that complainant everything that they're going to be challenging. So if they've got a witness who comes to say, well, I saw you there at a different time, they have to tell the complainant they have that witness. And that is the very first time that the prosecution team will learn that that witness exists. So doing that months before, or even a week before, completely undermines the normal process of how it all unfolds and changes the balance between the parties and changes the integrity of the process. So even though there are practical objections, there is also a principled constitutional objection that the integrity of the trial is challenged, that people have to show their cards at the wrong time. And I'd also just briefly draw, and it's mentioned in our submission, that the Court of Appeal in a case called M&R in 2011 went through these issues in some detail and pointed out everything that was wrong with them, including the perverse effect that sexual violence trials currently have priority in the system. And that's largely in recognition of the effect on the complainant of having this hanging over her. And if it was perceived that she could do her bit ahead of time and get rid of it, then that priority would be lost. So there might be a perverse effect that the importance of these things be undermined in the system. Right.
Yeah. I've done around 300 trials and coming up to 20 years at the bar. So I've got a fair degree of experience in these matters. And one of the things that's become abundant to me as we read the bill and look at the Law Commission research behind it is there appears to be a premise driving it. And I look at the Law Commission paper, the second review of the Evidence Act 2006. It says this at page 62. In sex trials, evidence of a false or allegedly false prior complaint engages issues of veracity, propensity, and sexual experience. Where the defendant alleges that sexual activity did not occur and the complainant is lying, a previous false complaint may indicate the complainant has a propensity to make false complaints and create doubt in the jury's mind about the truthfulness of the present allegation. Then there's this point. There are difficulties, however, with admitting evidence of a prior false complaint. First, it may not be clear whether the prior complaint was false. The obverse of that is regularly in jury trials now, we admit propensity about a prior conviction. Yet it may be true that the conviction itself ignores the fact that the defendant is innocent. That's just a fact. The other thing, and I go back to a case that I did some time ago, a gay woman moved in with her partner. They had a conjoined family. At her 30th birthday party, she passed out drunk on the couch, woke up and found the 14-year-old son of her partner penetrating her. She went to the police and made a complaint of being raped. The boy said that no, she seduced him. The police then believed the child, did no DNA analysis. The sexual penetration, according to both stories, were at different areas of the L-shaped couch. So the police chose to look at only one side of the coin, did no objective total analysis. This woman who went as a victim ended up being accused as a defendant. And the whole way through this process, the Crown in its cross-examination of her did exactly the same thing that various drivers and supporters of the bill say the defence do. They put her prior sexual experience to her as a gay woman to erode and attack her credibility. They said, how can you seriously say that you were raped? You've had sexual relations before the man because you've got 2 children, ignoring the fact that people as part of life come through and change. Sexuality is malleable. And yet, in that case there, it shows the vulnerability of a defendant who is gay. The other thing I would say is, I only have 30 seconds left, is that I heard before from the Speaker for the Disabled Persons Assembly, when asked by, I think you, Mr. Mitchell, some examples of the vulnerability of people who come to give evidence in cases, he pointed to the fact that there are 67% of inmates who've had a TBI, a traumatic brain injury. I had a case like this recently where a man who couldn't remember due to a head injury was accused of rape in relation to occurrences from 8 years before, from a woman who gave a 1.5-hour video interview. Yet when it came to trial, only a week before trial, when his sister came across from Australia to support him, she told me about a woman who was introduced as a great catch by the complainant in this current case in relation to her husband, in relation to her former partner. By that, what I mean is that this woman gave a 1.5-hour video interview at trial, attacking this man, accusing him of all manner of sordid rapes. And yet, only a week out from trial, We had an eyewitness who was told by that complainant within 2 weeks of relationship breakup that her previous partner was a great catch. Now, the relevance behind that is that's the sort of evidence that comes out. If you pre-record, it just stops the warp and weave and the reality of a trial when evidence comes on your doorstep at the last minute. That's just the way trials work. And this bill here ignores that reality. Open for questions.
Thank you so much, gentlemen, for your submission. Do I have questions from the members? Mr. O'Connor.
Yeah, thanks. And you've been here this morning. I asked the same question. Is it likely now that as a result of this, this is likely to increase the likelihood of the complainant having to give evidence twice if this goes forward? Is it, as defence, is more likely you will not endeavour, but as part of your case, have the complainant give evidence during the trial?
You're going to have to, as a matter of reality, twice or thrice. The other thing is the defence has to keep its powder dry, because until we get full disclosure, we often don't know the full nature of the Crown attack. And as a matter of reality, if you're going to have pre-recording like this, you've got to have the ability to respond in a meaningful way. So yes.
You would see that as probably a likely part of it.
Yeah, and it's not a matter of defence strategy, it's a matter of the reality of putting the case fully and fairly.
And can I just add to that? It's very unlikely a judge would turn down a request for a second bite at the complainant, because that would open up an appeal point.
So I think that's a very good example you gave, the anecdotal one. So what would happen in this case if you were to introduce what is it's evidence that can be introduced, because it's material, in relation to your witness evidence, and you already have a pre-recorded cross-examination of the complainant? How would the complainant respond to that new evidence?
Well, this is the difficulty, because you're actually loading memory. So you're not going to get an accurate recall, because the more often you expose a person to cross-examination, it's the same as psychological analysis. The more you do this, the more you tamper with the memory. And so it's better to do it once, and it's better to do it trial. So you have the free recall memory on the EVI, which is played, and which you see at the trial. But the other material, it would be best to put it before a jury. And let's be honest about this. One of the submissions talks about open court. When people give evidence in sexual cases as complainants, they're not an open court, it's a closed court. No one else is in there apart from the media. Names are suppressed, identity is suppressed, and the jury, the judge and counsel and court assistants. That's it.
Could I just speak to Mr. O'Connor's point? The Court of Appeal has already considered this idea of pre-trial cross-examination in substantial detail, and we set out 4 or so pages of their decision in against the Queen. Highly paid judges couldn't find one benefit out of this idea. They came out with 6 good reasons why it wasn't a good idea, and not a single one as to why it should be the rule. And can I just answer a question that wasn't asked of me, but I heard Mr. McIndoe ask it of someone else. You, sir, took interest in the fact that the Attorney General had given a report that did not take exception to this bill. Well, that has happened many times before in regard to Bill of Rights issues. And most particularly, sorry.
I didn't actually make that point.
Did you not? Was it Mr. Smith, Dr. Smith before you maybe?
Dr. Smith
Well, he
made
was
that.
just trying to
I
take
did
it
draw
because
attention
was
to the Bill of
Dr.
Rights.
It was Dr.
aspect,
Excuse me.
And there was the difference in the argument was being put forward by Elizabeth Hall from that we'd heard from the Ministry of Justice, and in particular guaranteeing the right to a fair trial.
Well, indeed.
That was the difference.
Well, I'm sorry, but you were quite right to point out that we do have a guarantee to a fair trial in Section 25 of the Bill of Rights Act, and the Attorney General did not take exception to this bill, whereas Section 25 says that you are guaranteed the right to cross-examine your witnesses or their witnesses. So this absolutely undermines that, fundamental right and freedom. It's saying that you don't have a guaranteed right, you have the reverse, and then you have to plead to be able to do that. Well, that is Kafkaesque. I can't believe that we're sitting here discussing the removal of the right to cross-examine your witness and to put your case fairly before the court as if this is all calm stuff. It isn't actually. And just to finish on the Bill of Rights point of the Attorney General, many times the Attorney General has presented reports which this Parliament has decided to ignore, and quite rightly. And the best example I can think of is in 2011, when the Attorney General decided, or his department rather, decided that the then Criminal Procedure Bill would not contravene fair trial rights. This House unanimously decided that that was in fact incorrect. So I encourage you to do that again, please.
Yeah, sorry, very quickly.
Yep, no.
I was just going to say that I completely, totally accept the premise that that a defendant's got the right to face their accuser and address those. There's no doubt about that. What we're trying to do is we're trying to find a way, and it's a very fine balancing act of removing some of the stress that actually a court environment places on a complainant trying to relive what is already, alleged a very traumatic time in their life, and that's we're trying to navigate our way through that. If you've got any ideas or anything that you can,
Well, it is already common that complainants give their evidence and cross-examination without being in the court. It's already common that that's done by video link. It's difficult to see how it could be made less stressful than that, given that she's got to front up, she's got to give her evidence somehow. And this proposal that she does it all at the same time as ourselves and many submitters have pointed out, it's got all sorts of problems with it.
The other thing I'd say as well is that in my coming up to 20 years now, only very occasionally have I ever had someone who I think is definitely guilty walk free. What burns me so deeply is when I have someone who I believe is most probably innocent goes to jail on dubious evidence because of a fettering of fair trial rights, and that concerns me greatly. And this is going to increase that opportunity more. It's dangerous.
Did you have a question?
I'm happy to waive it if we time.
No. I'll ask your question.
Thank you.
And then
Just
we'll...
very quickly, acknowledging the very good points that you and others have made about the difficulty of pre-recording cross-examination.
Yeah.
Would you not nevertheless say that the strongest argument in favour of it is around the malleability of memory, namely that is close in time to the alleged incident, as opposed to as close in time to the trial is the best time to tease out the facts of as the complainant would have them about what happened?
No, that works on a false premise. First off, closest to the time is often when the EVI is taken, which is evidence in chief.
Right.
But until you get the full perspective from the disclosure that will often come through at the 11th hour, a few days before, a week before trial, that's when you get the complete picture. And that's when you can put the challenge in. If you interfere prior to that with a series of repeat interviews and cross-examination, etc., and on half the facts, then in fact you are interfering with memory.
Right.
So if you want to get complete memory, you have to have it closest to the time as possible. That's one of the reasons, for example, why historic cases are so difficult. There's no statute of limitations here. When you've got a 25-year-old fact pattern or a 30-year-old fact pattern, you're going back to it. It's devilishly hard to find out what in fact actually occurred and what did not.
Okay.
All right, Chris. Gentlemen, thank you very much for your submission.
Thank you very much for your time.
Thank you.